Whatever you think of the attempt by Manhattan District Attorney Alvin Bragg to prosecute Donald Trump in connection with an alleged hush payment to a former porn star, there's no doubt that the events today in Lower Manhattan are historic. It is the first time ever in American history that a former United States president has been criminally indicted. As I said, we devoted last Wednesday's show, the full show, to examining what we knew would be the charges, namely that Trump, by paying these payments, which themselves were not illegal, in the eyes of the prosecutor, committed crimes by falsely describing what those payments were for, an internal Trump organization and Trump campaign records. And then that turned it into a felony by claiming that he did that with the intent to violate campaign finance law. And though at the time we didn't have the actual indictment or the charges or the prosecutor's theories laid out, we now do have that, and we can very much more clearly explicate exactly what the prosecutor is hoping to do and what the very severe vulnerabilities are in this indictment. So let's just begin with the basic facts, which is that Donald Trump has been charged with 34 felony counts, technically 34 felony counts. In reality, it's really just one crime. The crime being that he conspired with his then attorney Michael Cohen, along with the head of the National Enquirer, David Pecker, and others, not only to pay hush money payments to Stormy Daniels, the former adult porn star, but also to then cover up those payments. Again, paying somebody not to reveal information about you is not in and of itself criminal. That's done all the time. It's done in non-disclosure agreements, it's done in settlement agreements, and actually a lot of times victims of extortion or blackmail pay people not to reveal information that the people who are being paid claim to have about the person who's paying. So there's nothing illegal about paying hush money to somebody, even if you're a candidate running for office. So they need to figure out how is it that we can convert this act into not only a crime, but a felony crime. Because obviously if it were just a misdemeanor, it wouldn't even be worth attempting. And so what Alvin Bragg did, and again, Alvin Bragg is a Democratic Party district attorney who ran on a progressive platform, explicitly progressive, which is why his campaign was supported by a PAC that 6 days after it announced supporting Bragg, received a check for $1 million 6 days later from George Soros, which is why it's absolutely accurate to say that the Manhattan District Attorney is in fact a George Soros-backed prosecutor, because the Color of Change PAC that endorsed him and pledged to spend $1 million to promote Alvin Bragg's campaign in 2021, 6 days later received that $1 million, that exact sum, from George Soros. And then what he is now attempting to do, and I think it's worth remembering two things. First, Alvin Bragg originally did not want to bring this case. And the reason he didn't want to bring this case is because he knew of the very grave vulnerabilities and holes that this case presents. Two of his prosecutors resigned in protest and went public and accused Alvin Bragg of being unwilling or lacking the courage to prosecute Donald Trump. And only then did Bragg, who lives in Manhattan or lives in New York and is surrounded at all times by Manhattan liberals, feel the pressure, the political pressure, to bring this case. Not only that, the transactions at the heart of the indictment, not only the payments to Stormy Daniels, but also the attempt to depict them as something other than that, were looked at both by regulators of campaign finance law inside the United States government as well as federal prosecutors, both of whom concluded that there was no evidence sufficient to prove a crime or that it would not be wise to try and convert these events into a crime. It took a local district attorney in ground zero of American liberalism, which is Manhattan, in order to do it. And the way in which he has done this is to take a single act, namely that every time Michael Cohen, Trump's then lawyer, sent a bill or an invoice for this money that he had paid to Stormy Daniels, calling it legal services, and then every time the Trump campaign took that invoice and entered it into the account, into the records, and then every time they paid Michael Cohen and then entered it into the records, Each time they did that, those 3 acts, received the invoice from Michael Cohen, entered it into the records, and then paid him and entered the payment into the records, each one of those acts constitutes a crime of falsifying business records with the intent to defraud the public by concealing a crime. So you get to 34 because they did that 11 times over the course of 11 months. And so the indictment is nothing more than a repeat of that same act, that same central act, that same crime over and over and over and over and over again. And it's structured so that each individual act is its own count. So it's really just one crime, but it predictably produced this very dramatic, melodramatic headline of 34 felony charges, making it seem as though this avalanche of criminality has poured down on Donald Trump's head. And usually the crime that's being alleged, which is falsifying business records, is in almost every case nothing more than a misdemeanor. But again, there would be no political value to accusing Trump or indicting Trump on a misdemeanor charge. The only way it would be exciting, the only way it would have value to the Democratic Party, to American liberalism, to the media, is if you found a way to escalate that misdemeanor into a felony charge. And the theory used by Alvin Bragg when doing so is that when Trump concealed these payments, or the purpose of these payments, by pretending that the payments to Michael Cohen were for legal fees as opposed to reimbursing him for paying off Stormy Daniels, the intent was to cover up a separate crime. Only then can falsifying business records be converted into a felony, if the intent in falsifying the business records is to conceal some other crime. So the question is, what crime are they alleging Trump was concealing? Because again, paying off somebody, even a porn star, to stay silent and not to accuse you of doing things is not illegal. So what crime was he trying to conceal? And the indictment now makes clear that the alleged crime that Trump was trying to conceal was that he violated federal campaign finance law. Because according to the prosecution, the purpose of these payments was to influence the 2016 election, to increase Trump's chances of winning the 2016 election, and therefore it was really a campaign expenditure. Even though a person in Donald Trump's position would have all sorts of other motives for wanting to pay off someone who would accuse him of having sex with them while they were a porn star 3 months after he had a new child. Personal embarrassment, protecting your family, avoiding embarrassment for your wife or your children. The allegation is that he only had one overwhelming purpose, which was to influence the 2016 election by ensuring that this information wasn't known, and therefore these payments were in fact campaign expenditures, similar to buying ads on television for your candidacy, or sending out mail, or paying people who work for your campaign. And that as a result, these expenditures had to be disclosed and treated as campaign expenditures under campaign finance law. And because Trump never declared them as campaign expenses, instead he worked to conceal them, so this theory goes, then it was a violation of federal election law, because federal election law requires that you disclose these payments, and he didn't do that. That's the theory. And that is how they took what is at best a single misdemeanor count of paying off Stormy Daniels, but recording it as a payment to Michael Cohen for legal services, and escalated it or elevated it into 34 felony charges by claiming the intent of concealing it was to violate federal election law. Now, there's 2 gigantic problems just with this part of the case alone. Number one, even if the Manhattan District Attorney can prove everything I just said, that that was Trump's intent, and that by doing so he violated federal election law, even though, again, federal campaign finance regulators and federal prosecutors chose not to pursue this, even if they can prove that he violated federal campaign finance law and his intent was to conceal it, just under New York law, the theory that he would have to use, which is that the crime that you're attempting to conceal can be a federal crime, not just a New York State crime, is very dubious. Remember, this is a New York State prosecutor. He's not a part of the federal system. He can only enforce New York State law. He has nothing to do with federal law. So the question of whether or not you can even commit this felony by trying to conceal a federal crime, namely violation of the federal campaign finance regulations, is completely uncertain. New York courts have never ruled on that question. They've never ruled that you can violate this statute in a way that makes you a felon by concealing a crime that is federal in nature. So courts are going to have to decide that question for the first time, and if they decide it against the prosecutor by saying, of course, this is a New York State court, this is a New York State prosecutor, you can't commit a felony under New York State law because of a federal law violation, very, very likely, or possible at least, that a court will do so, the entire case disappears. It means that even if everything they say about Donald Trump is true, both his actions and his intent, it's just not a felony under New York law as courts will interpret it. That's a gigantic hurdle. It's a huge gamble. It's the reason why Bragg didn't want to bring this case until he got politically pressured to do so. He does have a second theory that Trump also violated New York law, election law, by presenting a candidacy to the people of New York based on false pretenses, or by trying to conceal a crime. It's an incredibly vague law. There's no way a person would have advance notice or due process notice that that would even be a violation of this law, and I seriously doubt courts will accept that state law interpretation. The question is, will they conclude that you can actually commit a felony under New York State law by violating federal law? And that too presents the due process problem, which is because this question has never been answered by a court, you can't try and convict somebody of a crime whose existence was very unclear, because the only way due process is satisfied is if a person is accused of committing a crime that they had reason to know was actually a crime. So there's all kinds of reasons why, even if they can prove that Trump did everything that they say he did with the intent that they claim he had, this is a crime in the first place. The other extreme difficulty is proving that Trump's intention when paying Stormy Daniels this money, assuming they can prove he did that, was overwhelmingly or primarily to influence the election. As I said, there's a million other different motives one might have in not wanting that information to surface. And a very similar case happened in 2012, which we will review, when federal prosecutors tried to prosecute John Edwards, the former Democratic senator, the vice presidential candidate in 2004 on the Democratic ticket with John Kerry. When he was running for president, he had two very rich donors pay $900,000 to his mistress, Rielle Hunter. And because that was concealed, they prosecuted him based on the same theory. And the jury acquitted him on one count and couldn't reach a verdict on the other four. And that's because there was no way to prove his motive. There was no way to prove that his motive in paying off his mistress was primarily electoral as opposed to protecting his family or his reputation. And they're going to run into that same problem. That's why I say, when you add all these things together, including the fact that this is brought by a Soros-backed prosecutor in the heart of American liberalism, I'm in favor of holding even ex-presidents accountable for crimes they commit, but you have to make sure you have solid footing to do that, and this is the opposite of that. So let's just look at a couple of the basics. First, from the New York Times today. There you see the basic story on the screen. Even the New York Times acknowledges, quote, Donald Trump has been charged with 34 felony counts of falsifying business records in the first degree. The former president pleaded not guilty to all counts. The charges against Mr. Trump are all Class E felonies, which are the lowest category of felony offense in New York, and carry a maximum prison sentence of 4 years per count, though it's inconceivable that he would ever get anything close to that. Under New York law, falsifying business records is generally a misdemeanor. But prosecutors can escalate the charge when they believe a person falsified business records in order to commit another crime or hide the crime, the committing of a crime, and that's their challenge. As the New York Times says, quote, for Mr. Bragg, a Democrat, a conviction is no sure thing. The falsifying business record charges appear to hinge on a novel application of the law. Even liberal media outlets are acknowledging that this case has been brought on a very precarious footing. Here, for example, is an article in Vox from today by their legal correspondent, who I would venture to say is probably the single most partisan Democratic loyalist on all of media, Ian Millhiser, if not one of them. I would say he probably is the leading one. And he admits, as you see in this headline, quote, the dubious legal theory at the heart of the Trump indictment explained no one knows if Donald Trump can be prosecuted for the hush money payment to Stormy Daniels. And his article, and again, this is Vox, as Democratic of an outlet as you get, acknowledges just how vulnerable this case is. Quote, the actual felony counts arise out of allegedly false entries that Trump made in various business records in order to make the payment to Daniels appear to be ordinary legal expenses paid to Cohen. But Bragg built his case on an exceedingly uncertain legal theory. Even if Trump did the things he's accused of, it's not clear Bragg can legally charge Trump for them, at least under the felony version of New York's false records law. As Mark Pomerantz, a former prosecutor in the Manhattan DA's office, who played a significant role in the Trump investigation prior to his resignation in 2022, so that was one of the prosecutors who quit and publicly accused Bragg of being too much of a coward to bring this case, as even he wrote in a recent book, a key legal question that will determine whether Trump can be charged under the felony version of New York's false record law has never been resolved by any appellate court in the state of New York. The felony statute requires Bragg to prove that Trump falsified records to cover up a crime. Bragg has evidence that Trump acted to cover up a crime, but it is not clear that Bragg is allowed to point to a federal crime in order to charge Trump under the New York state law. The answer to this, quote, gnarly legal question, as Pomerantz put it, is simply unknown. So there's a serious risk that a New York judge will toss out the charges against Trump on technical legal grounds unrelated to the former president's actual conduct. Again, if you're going to bring a case against the former president, which I am not opposed to in theory, I wrote a whole book, as I reviewed the other day, in 2011, arguing that this two-tiered theory of two-tiered justice system, where elites, both business and political, are immunized to prosecution, and whereas working class people and poor people are put into prison in gigantic numbers, is a grotesque vandalization of what a justice system is supposed to be. But if you're going to do this, especially a Democratic prosecutor bringing a case not just against a Republican former president, but against the Republican frontrunner, you need to make certain that you're doing it in the most apolitical way possible, in the most trustworthy way possible, only where there are serious charges to be brought, and where there is a clear-cut law that you can claim has been violated. None of those is true in this case. None of them is true. It is the worst possible case for Democrats to have had to bring, and I think even they're embarrassed. They were hoping it was something more consequential, like Trump being accused of inciting an insurrection, or even mishandling classified information by taking them to Mar-a-Lago, something meatier than a Democratic Party judge, district attorney in Manhattan, indicting him for something that may not even be a crime at all. Now, as I mentioned, it's really worth remembering. Thanks for watching this clip from System Update. Catch our full shows for free, live weekdays at 7 p.m. Eastern on Rumble, and join our locals community at greenwald.locals.com for all of my written journalism, exclusive after-show Q&As, and more.